A very good morning, one and all. On behalf of National Law University, Delhi and Justice Bodh Sawhny Memorial Trust, I welcome you all to the 19th Annual Bodh Sawhny Memorial Oration 2018. To grace the occasion, we have with us today Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, Professor Dr. Ranveer Singh, Vice Chancellor, National Law University, Delhi, Professor Dr. G.S. Bajpai, Registrar, National Law University, Delhi, Professor L.N. Nath, Chairman, Bodh Sawhny Memorial Trust, Mrs. Meera Nath, Managing Trustee, Bodh Sawhny Memorial Trust, and other esteemed members of the Trust. Now I request Honorable Vice Chancellor, Professor Ranveer Singh, to give the welcome address.
I extend a very warm welcome to Honorable Justice, Dr. Justice Sawhny Chandrachud, Judge Supreme Court of India, who is kind enough to agree to deliver the 19th Bodh Sawhny Memorial Oration 2018. Honorable Dr. Justice D.Y. Chandrachud sir, today we have not only invited you to deliver the oration lecture, but we have summoned your good self this morning to hear our unanimous declaratory verdict. Our verdict is a decree of extreme love and affection and admiration for you. Let me also declare that these proceedings, which are ex parte, declare that we are also your judgment debtors. In a span of 17 years, first as a judge of the Honorable Bombay High Court, then as the Chief Justice of Honorable Allahabad High Court, and presently the judge of the Honorable Supreme Court of India, your honor has brought unique distinctions to the most prestigious Supreme Court of India through your innovative judgments. Sir, you have opened the doors of your courts through your judgments for the poor, needy, indigent, your concern for the common man, and for your commitment to human rights. Your allegiance to jurisprudence and role of justice have greatly enriched the judicial literature in country. Despite your obvious brilliance in intellectual pursuits of a variety of kind, you remain extraordinarily humble. We are great admirer of your restless and rebellious quest for justice. You have always dared to explore new grounds of justice for one and all. Your many leading judgments in the fundamental rights, human rights, have given new principles of jurisprudence. Your shining faith in the rule of law compel us to request your honor to share your views on the rule of law in a constitutional democracy. Madam Mrs. Meera Nath has always been a great support for all the activities under the trust. I extend a very warm welcome to you, Madam. I also welcome Professor Lalit Mohan Nath, Chairman, BRSMT, and all other trustees and members of the trust. I welcome the registrar, the faculty, the administrative staff, and most importantly, the dear students. I welcome you all once again. The Bodh Sawhny Memorial Trust has given donation for Bodh Sawhny Memorial Oration. They have also given us money for the memorial lecture for cash prize of the students of LLB. Late Sri Digambar Sawhny, former settler and former founder, trustee of Bodh Sawhny Memorial Trust, has individually donated good fund to NLU Delhi for the constitution of the Bodh Sawhny chair, and he donated us 1 crore rupees for professional ethics at NLU Delhi. It's a great moment for us to have the Honorable Judge with us while going through some of the important books on this subject. So I'll just make very brief comments. Harvard lecturer Monk says, citizens have long been disillusioned with politics. Now they have grown restless, angry, even disdainful. These are very strong comments by. From Russia and Turkey to Poland and Hungary, elected strongmen, the word used is elected strongmen, are turning democracies into electoral dictatorship. How do we stop this? In another book, The Retreat of the Western Liberalism, Edward Luce says, hostility to Western notions of progress tries to answer the question, are they wrong? The backlash of the West middle class, who are the biggest losses in global economy that is rapidly, but still has decades to go. And what is the way forward? Timothy Snyder on tyranny presents 20 lessons from 20th century adapted to the circumstances of today. Some of them believe in truth, be calm, but he says unthinkable arrives and be courageous as you can wait for tomorrow. Let us wait for tomorrow, which is going to be bright and good. Thank you very much.
Thank you very much, sir. And now may I request Madam Mrs. Meera Nath, the Managing Trustee of Bodh Sawhny Memorial Trust, to speak about the trust. Thank you.
Good morning, everyone. Honorable Dr. Justice Chandrachud, dignitaries, Professor Dr. Lalit Mohan Nath, Chairman BRSMT, Professor Ranbir Singh, VC, Professor Bajpai, esteemed guests, faculty and students of NLUD. The Bodh Sawhny Memorial Trust was founded in 1999 by my late father, Shri Digambar Sen Sawhny, in memory of his father, Justice Bodh Sawhny. Bodh Sawhny was an eminent jurist who was born in Bhera, Shahpur, Punjab, now in Pakistan. His early education was at St. Thomas College, Murray. He joined Cambridge University in the Michaelmas term in 1899. In September 1900, he migrated to Downing College. In 1902, he received the degree BA and LLB from Cambridge University. He was called to the bar Lincoln's Inn on January 26, 1903. In 1902, he joined Exeter College, Oxford, and received the degree of Bachelor in Civil Law in 1904. He was a tennis blue in both Cambridge and Oxford. On his return from England, he practiced at Lahore and held the office of Government Advocate of Punjab. In 1907, in the Pindi Armory case, his father Lala Hansraj Sawhny and Sardar Ajit Singh were arrested by the authorities and tried for conspiracy and insurgency against the British Crown. Bodh Sawhny and Razaida Bhagat Ram Sondhi, barrister from Jalandhar, defended the case and got them exonerated. In 1910, Maharaja Pratap Singh, then ruler of Jammu Kashmir state, appointed Bodh Sawhny as Chief Judge of the J&K Judicial Service at Jammu. Bodh Sawhny was appointed Superintendent of the camp during the coronation Darbar of King George V and Queen Mary held at Delhi in December 1911. He was conferred the title of Rai Bahadur. Bodh Sawhny was instrumental in framing the constitution of the High Court of Jammu and Kashmir and was elevated to the High Court bench in 1928. He served in the High Court from 1928 to 1936. During his tenure on the High Court bench, he also acted as Chief Justice of Jammu and Kashmir. His wide range of interests included horticulture, motoring and shooting. The aims and objectives of the Trust are to promote excellence in legal education, to promote community health, to promote conservation of the environment and upliftment of women. The Bodh Sawhny Memorial Trust is working with national law universities and law colleges all over India. BRSMT supports scholars for higher education in legal studies with scholarships. We have instituted a scholarship for Indian students for the BCL course at the Exeter College at Oxford University in the UK. We are funding moot court competitions, debates and essay competitions at the National Law University Dwarka, NALSAR at Hyderabad, the National Law University at Bangalore, the National Law University at Kolkata, the Law School at Jammu University, and the GLC at Mumbai. Every year an annual Bodh Sawhny Oration is held. There have been 18 annual orations which have been delivered by legal luminaries on important legal issues. Late Justice A.S. Anand, former Chief Justice of India, has been the chairman of this trust and delivered the first annual oration. Honorable Justice J.S. Verma, Honorable Justice Kuldeep Singh, Honorable Justice R.S. Pathak, Mr. Soli Sarabji, Dr. Heinz Godar, Honorable Justice M. Ken Venkatachalya, Mr. B.P. Jeevan Reddy, Mr. Fali S. Nariman, Professor Dr. Upendra Bakshi, Shri Wajahat Habibullah, Professor N.R. Madhava Menon, Shri P.P. Rao, Dr. Shashi Tharoor, Honorable Justice A.K. Sikri, Professor Dr. V.V. Reddy, Mr. Richard Verma, Mrs. Aruna Roy, and have been the speakers of the previous orations. It is indeed a great honor for us that Honorable Justice Chandrachud is going to deliver the 19th Bodhraj Sawhny Memorial Oration on the rule of law in a constitutional democracy. May I request Your Honor to kindly address this gathering.
Professor Dr. Ranbir Singh, Dr. Bajpai, Mrs. Meera Nath, Dr. Nath, former director of the All India Institute of Medical Sciences, distinguished guests in the audience, and all the students and members of the faculty. It is indeed a great honor for me to visit National Law School in the very first time that I'm going to be speaking here. I've meant to come to the National Law School for a very long time, but I think the exigencies of reading 70 special leave petitions for Monday morning, and then you barely got out of this onslaught when you have another 70 on Friday, and then you have about 15 odd every day, meant that I have to keep to where I should be, namely my chambers. But I was just thinking to myself that, you know, in token of my great exhilaration of visiting your institute, I'm going to pinch that little notepad which says NLS Delhi. So even though I never really got to study at NLS Delhi, this will really remind me of my very first visit here. I'm 19th in the list of speakers who have spoken on this lecture series. And as Mrs. Nath was narrating the names of those speakers, I said, I have a really tough task to discharge this morning, coming to speak after a galaxy of speakers, and particularly because the lecture series is dedicated to the memory of such a distinguished judge. I think you need to understand the lives of these people who worked before independence, people whose lives were in that sense closely associated with the movement for freedom. And in fact, that is one of the reasons I thought I should choose this morning's subject for my discourse, which is not just the rule of law, because if I were to speak just about the rule of law, I'd probably tell you about Dicey, retrace my steps when I was being taught law in 1979 in the Delhi University, and probably conclude my speech. But I think it's the element of the constitutional democracy which imparts somewhat different a texture to what I'm going to be speaking about this morning. Because this lecture is not just about what is the rule of law, but it is also about how does the rule of law find specific meaning in our constitutional democracy, and how does the rule of law produce a theory of adjudication. And the third facet which I'll cover in my lecture is about the limitations of the role of the judiciary in creating the rule of law, the limitations of adjudication itself, and that's where I'll speak about the importance of associating non-judicial institutions in enhancing the rule of law. While speaking of the rule of law, I begin with a simple question which was posed by the renowned political theorist Stephen Holmes. Why do people with power accept limits to their power? An even more pointed formulation is, why do people with guns obey people without guns, without the might of the state? An economic twist to the argument would be, why would those who are well endowed ever voluntarily part with a portion of their wealth, of their resources? In legal theory, a parallel question is, why do politicians sometimes hand over power to judges? And we see that happening in the Supreme Court every day. We saw that in 377 where the government told us that we are leaving this to the wisdom of the court. And this wisdom of the court was too enticing a principle for me not to respond. So I responded in my judgment the other day. I'm not sure whether you've seen that because it was really an obscure part of the judgment. I said it is well for a judge to remind himself or herself of the fact that flattery is often the graveyard of the gullible. So why do politicians allow judges who neither control the purse nor the sword to overturn and obstruct their decisions, and sometimes even send office holders to jail? These questions really are overly broad and indeed considerably vague to be answered with any degree of certainty or comprehensiveness. They nonetheless provide to us a starting point, so to speak, to pry loose some of the salient insights about the origins, evolutions, and the limitations of the rule of law in a constitutional democracy like ours. The rule of law subserves various important constitutional values, including legality, certainty, accountability, efficiency, due process, and access to justice. So at a certain level, the rule of law has a very formal function. The formal function really reminds you of John Fuller's internal morality of the law. And when you speak of the internal morality of the law, you refer to concepts such as the generality of the law, publicity of the law, prospectivity of the law, intelligibility, consistency, practicability, stability, and congruence. So there you have in each one of these adjectives, if you contrast this with reality, you very often realize how different reality is from what you actually see. The law is not necessarily general. The law should be, but is not as public as it should be. It may not be necessarily prospective. In Vodafone, the Parliament decided to enact a statutory amendment to the Income Tax Act with effect from 1962, which created this huge furore in international business. The law is not necessarily intelligible. It may not be consistent. It may not be practicable. The law may not be stable for the simple reason that different judges respond differently to the needs of the law, and the law may not be congruent. But apart from the formal concept which I associate with John Fuller, the second is the more procedural concept of the law. And the procedural concept which Dicey essentially spoke of was the notion that you should be heard by an impartial tribunal, an independent tribunal, where you have a right of representation, a right to confront, the right to reasoned argument, and the right to a reasoned dialogue between various stakeholders in the adjudicatory process. And the third element is really the substantive element. And the substantive element is this: that the content of the law will be determined or evaluated in order to determine whether the law is compatible with the moral rights or the natural rights which citizens possess. Now, Dicey, when he made his formulation, I think we've all, at least judges of my generation, have grown up with the formulation by Dicey on the rule of law. And Dicey's postulate essentially was based on the principle of the sovereignty of Parliament and of the rule of law. In fact, when Dicey made his formulation, he described how foreign observers who visited England were astounded by the fact that England was a country distinguished by the fact that it was under the rule of law. And Dicey says that when Voltaire came to England and he represented the feeling of his age, his predominant sentiment clearly was that he had passed out of the realm of despotism to a land where the laws may be harsh, but where men were ruled by law and not by caprice. So the rule of law conception, as it was originally evolved, was consistent with laws which were unjust, laws which were harsh, but the fact that there was law which provided a source of authority to judges, to politicians, to society at large, provided really a justification for the concept itself. By allowing for so-called harsh laws to exist alongside the rule of law, it is clear that Dicey did not equate the rule of law with the notion of a good law. Nor did he contend that in order to qualify as a law, a particular rule of law must be necessarily fair, reasonable, or just. This then begs the question, what did Dicey mean by the rule of law? And there were three overlapping concepts which Dicey propounded. Namely, first, that there should be a control on the exercise of discretionary power. Second, that there should be no punishment without a pre-existing law. And third, that all power must be authorized and exercised through ordinary courts of law. Dicey's second principle, and that's where I'll take off and leave Dicey, engaged a notion of equality, what he referred to as the equal subjection of all individuals to a legal regime, of all classes to one law administered by the ordinary courts. Dicey's primary concern was that public officials should not have special immunities or privileges, and that they should be held accountable by ordinary private causes of action before your regular courts of law for their official conduct, no different from anyone else. Now, when we look at how the rule of law, as you originally understand it, has been shaped in a constitutional democracy, I think no understanding or explanation of the subject would be complete without referring to the context in which it has worked. This context, the social and the political context, adds an additional layer to the existing theoretical discussion on the rule of law. In our constitutional democracy, and that's really my postulate this morning, and I'm going to speak about some of our recent cases as we go along. The first is, what is the law in a constitutional democracy intended to achieve? The first and basic premise which I want to place before you is the transformative role of the Constitution. What is it that the Constitution seeks to achieve in terms of the rule of law? And that, to my mind, the crucial element in that is that the Constitution itself is intended to transform society. In what context was the Constitution enacted? There were inherent tensions in the drafting process in the Constituent Assembly between social reformation and the preservation of a long-standing status quo, of a purely feudal society, of an essentially patriarchal society. So the process of constitutional draftsmanship reflects first and foremost a movement for political freedom. The Constitution essentially was drafted in the context of the freedom movement, the movement that people should have civil and political liberties and rights. But parallel to the freedom movement that was taking place before the advent of the Constitution, there was a parallel social movement as well. And that social movement was reflected in the work of people like Dr. Ambedkar, or before him, people who really preceded him, like Jyotiba Phule in Maharashtra, or Savitribai Phule. So these were people who were essentially battling against a society based on prejudice, on immutable features, and of discrimination against whole swaths of our society. So when you look at the Constitution, there is an unmistakable emphasis which you find in our Constitution of a commitment to a transformation of relations, the relations between the individual and the state, and between individuals themselves. This transformative vision of our Constitution underlines its working and interpretation. The rule of law in this background enjoins the recognition of these tensions and a vision of a society which is headed towards dignity, liberty, and equality. Soon after the Constitution was enacted, you find in our rule of law approaches to the interpretation of constitutional rights this divide between the formal and the substantive. Dicey represented a formal perspective, but it is not as if that this divide between the formal and the substantive aspects of law was lost to the process of constitutional interpretation in India itself. Take for instance the theory of classification as it emerged after Anwar Ali Sarkar and a whole series of cases. Equality as that overarching principle of our part 3 was reduced to a formula, and equality by being reduced to a formula basically meant that the doctrine of equality would be satisfied, as you know, the classical formulation, if you had an intelligible differentia. Second, if there was a rational relationship between the intelligible differentia and the object of the law. But what the theory of classification did to the rule of law was to reduce substance to merely the form. Because by emphasizing on classification between, say, 1952 right down to Royappa, which came in 1974, our jurisprudence tended to focus on the formal nature of the adjudicatory process as opposed to exposing the real substantive underlying values which lie at the foundation of all constitutional adjudication. Or take the notion which emerged after Gopalan, that each fundamental right in that sense was independent of the other. What this generated in our law was a formalistic doctrine of constitutional jurisprudence. Namely, that when you have, for instance, an order for preventive detention, you will test it with reference to Article 22, but you will not assess the impact of an order of preventive detention in terms of its consequence for other rights like 19 or 21. So the theory of rights being essentially disconnected, of rights being disjunctive, of rights not being holistic, gave rise to artificial definitions in constitutional law. It gave rise to an approach towards constitutional law which misses the central aspect of the human personality. That the human personality in that sense is holistic, it is one. So whether you are exercising the right of free speech, whether an individual exercises the right of free speech, whether the individual exercises or asserts an entitlement to be treated equally, or whether an individual asserts a right under Article 21 to retain the core of her privacy, it is one individual who is exercising that right. And very often individuals exercise composite rights, rights which are in conflict even when an individual is exercising them. So the rights which really in that sense interact with each other, which have an interface with each other, are not necessarily only the interactions with the state or interactions with other individuals, but an interaction within the personality of an individual, because each of us is exercising at any one given point of time a multitude, as it were, of composite rights which give rise to a multitude of identities. So I think in understanding the interface between the rule of law and constitutional adjudication, we need to understand the real limits of the jurisprudence of the Supreme Court as it evolved, right through probably until the post-emergency years, because we tended to miss the central connection of rights between individuals, within an individual, in the evolution of the human personality. Now, Keshwananda, for first time, Keshwananda Bharti propounded the doctrine of the rule of law being part of the basic structure. Justice Khanna, in his seminal dissent in ADM Jabalpur, said, what if there is no law? If you have no law, can you envisage a situation where there are no rights? Which really, in that sense, emphasizes a central feature of the entire rights discourse, that are rights dependent on the Constitution, or is the Constitution a formal recognition of the existence of rights which devolve on us as individuals, independent of the Constitution? So if there is no law which seeks the protection of rights, or if there is no constitutional superstructure which provides for the protection of rights, does that mean you have a society without rights at all? And that's, I think, what Justice Khanna was referring to when he made that statement. You have before both Keshwanand and ADM Jabalpur the classical statement by one of our most liberal judges, Justice Subbarao, in Golaknath, wherein Golaknath, Justice Subbarao sought to make that balance between the egalitarian facets of the Constitution, the social welfare entitlement doctrines of the Constitution, and the political liberties doctrines of the Constitution. And then finally you have Justice Krishna Iyer in Dabholkar, when he said that the rule of law cannot lay claim to be built on the ruins of democracy. So these four basic premises which emerge from Golaknath, from Keshwanand, from ADM Jabalpur, and then finally from Justice Krishna's decision in Dabholkar, tell you about this close interface between the rule of law and democracy, and within a democracy, as it were, the close interface between rights of a political nature and rights of a socio-economic nature. Now, in the last few years, there have been issues which have been emerging before us, and I thought I should spend a little time with you dealing with those issues until I finally go to the most recent of them, which was our judgment in 377 in Nafte Johar, which we delivered just a few days ago. And I want to dwell on these 4 or 5 judgments to tell you about the substantive versus the formal aspects, and how there is this constant tension in the mind of the judge and the craftsmanship of the judge in seeking to craft a decision which seeks to preserve both the formal as well as substantive element of the rule of law and the working of democracy. First, I would take you to the decision on the ordinance making power. As you know, Article 123 and Article 213 give power to the governors in the states and to the President to formulate ordinances at a time when Parliament or the state legislatures are not in session, and where an extreme situation has arisen warranting the exercise of the ordinance making power. Now, ordinances are an exception to rule of law. They are an exception to the rule of law for the reason that though the Constitution tells us that the ordinance making power shall be treated as a power of lawmaking, so the ordinance making power does satisfy the formal notions of the rule of law, because the Constitution, by a deeming fiction, tells you that it shall be law for the purposes of the Constitution in Article 13. But yet, there is a substantive element which is lacking in the ordinance making power in its connect with the rule of law, which is the institutional connect. The institutional connect is this, that a law must be framed by the legislature, because it is in the course of the law being framed by the legislature that there is a great deal of circumspection, of reflection in the committee making, in the law making processes in the committees, when you have a variety of stakeholders who come and assert interests which may be contrary to the interests which the government seeks to espouse in the framing of law. So what the ordinance making power essentially does is to deprive a diversity of stakeholders in society from representing perspectives in the process of lawmaking. Article 123 and 213 are silent on how the subjective satisfaction of the governor or the president would be evaluated. If the governor or the president feels that, well, there are circumstances which warrant the exercise of the lawmaking power, would this be subject to judicial review? Next important aspect, what happens when, through an ordinance, the government seeks to lay down consequences for the future? The life of an ordinance, as you know, is limited to 6 months and 6 weeks, because Parliament has to be convened within an interval of 6 months, and an ordinance has to lapse 6 weeks, no later than 6 weeks after the legislature is convened. So the life of an ordinance is 6 months and 6 weeks. But what happens when the legislature, in the course of framing an ordinance, lays down consequences for the future which will outlast even the life of the ordinance? So in the course of a lawmaking power which is essentially transient, though a lawmaking power, as the Constitution tells you, can the legislature leave consequences which will bind us for posterity? Can they alter the rights discourse in our society? Technically, and using a formal rule of law notion, that can be possible. But we tried in Krishna Kumar Singh last year, judgment which was delivered in Krishna Kumar Singh by 7 judges, to try and balance the formal perspectives of the rule of law with the more substantive perspectives of the rule of law, which was to say that firstly, the decision of the president or the governor in regard to the satisfaction on whether the ordinance making power was required to be utilized would not be final. It would be subject to judicial review. In A.K. Roy, the Supreme Court said that as a result of the constitutional 42nd amendment, possibly it is not going to be final and it would be subject to judicial review. But by the time A.K. Roy was decided, the National Security Ordinance had been replaced by the National Security Act. So they left the question open. We thought that when we decided the 7-judge decision, that let's clear the ground for future. Namely, that the satisfaction of the president or the governor would be reviewable. So there would be this interinstitutional reviewability of the satisfaction of the president or the governor. Second, if the ordinance making power by its very nature is intended to last during a segment of time when Parliament is not in session, how can you envisage a situation where the executive, in the exercise of an exceptional power, seeks to bind posterity, to alter rights, to confer new rights, to impose obligations? So we held that unless a situation arises where the rule of law or public interest warrants it, we will not accept a situation where consequences for posterity are laid down beyond the life of an ordinance. Simple case. Suppose the government enacts an ordinance and says that every illegal structure in Delhi is regularized. Suppose the government enacts an ordinance and says every ad hoc employee, you have say 100,000 ad hoc employees in a state, every ad hoc employee is regularized, though they've all come in through the back door in violation of Article 16. Can an ordinance have that effect which lays down those consequences for posterity? The answer to that is simply no, because that would be to trump the formal notions of the rule of law with the more substantive notions of the rule of law. Or take the second example which I want to emphasize this morning, which was the entire debate on euthanasia. You have, on the one hand, statutory provisions in the penal code which make an attempt to commit suicide unconstitutional and illegal. An attempt to commit suicide is a penal offense and therefore necessarily a violation of law. But you also have a situation where individuals have a right to live with dignity. You have the Mental Health Act today, and the Mental Health Act has made a quantum difference to the entire regime on mental health, and particularly in relation to the attempt to commit suicide. Because what the Mental Health Act did was to treat an individual who attempts suicide is not a violator, but essentially is a person who is a victim, and a victim of social circumstances, a victim of economic circumstances, a victim of just a variety of things which afflict individual lives. So one of the key issues which came up before the court when we dealt with the euthanasia case was simply this: you have no law at all. What Justice Khanna spoke in his dissent in ADM Jabalpur. You have no law at all regulating, as it were, either particularly not regulating passive euthanasia. Insofar as active euthanasia was concerned, there is obviously a law, and that law, as you know, is the penal code. A variety of provisions of the penal code, starting from 300, then the punishment under 302, and then of course 304, and so on and so forth. But insofar as passive euthanasia is concerned, does an individual in that sense not have the right to postulate for now the ability to refuse medical treatment, postulate for the future that should my situation so evolve in future as to deny me the right to live a dignified existence, can I not lay down in advance what should be the course of action that should be followed in future? Now, we laid down two things, which is that while active euthanasia, as it is called, I mean the active-passive divide itself is extremely problematic, something which I have developed in my judgment, but I'm just using these terms as very as loose terms for your consideration. And the active and passive distinction, active euthanasia may be something which is contrary to our law, but we ruled that passive euthanasia, and as an incident of passive euthanasia, the right of an individual to make an advance will, so to speak, would have to be upheld in our law. And in laying down the norms for advance wills, we also again relied on several provisions of the Mental Health Act. So euthanasia is another area where you find that the court is engaged in this very deep evaluation of the formal versus the substantive notions of the rule of law. What is it that you really want to protect? Do you want to create a society for the future in which individual dignity, individual autonomy, the individual right of choice has any significant bearing? And this was really in that sense a theme which emerged from Puttaswamy, which was exactly about a year ago. Take the third element. I'm not going to deal with Puttaswamy specifically because I'm going to deal with the decision in Johar. Take the third illustration, the decision on whether recourse can be taken to reports of joint parliamentary committees in judicial proceedings. The argument which was urged before the court was that reliance on the report of a joint parliamentary committee in the course of an adjudication, particularly of a social interest litigation, would infringe upon parliamentary privilege. The submission before the court was that a parliamentary committee submits its report only to Parliament. It doesn't submit it to the court. A parliamentary committee is subject to internal control by Parliament. And to the extent to which parliamentary committees are therefore subject to an internal parliamentary control, there can be no evaluation, there can be no challenge to a parliamentary committee report in a court of law. Now that again represented, as it were, the formal versus the substantive. Formally, yes. For instance, you cannot call into question a vote which is given by a member of parliament. In the famous bribery case, that was what the Supreme Court held. That you cannot call into question in a court of law why a vote was given by an individual member of parliament in parliament. You cannot call into account an individual member of parliament who speaks either before a committee or before parliament in a court of law. That is really that was intended to subserve the purpose of the freedom of expression in parliament. But more significantly, in Kalpana Mehta, what we really had to deal with was this: the separation of powers has traditionally been associated as an integral element of the rule of law. And the separation of powers as it evolved in India as now a part of the basic features of the Constitution, has for long been assumed to be a one institution, one function approach. So Parliament will legislate, the executive will administer the law, and the judiciary will in that sense adjudicate over disputes or rights under the law. But is this notion of the rule of law and separation of powers, which postulates a one institution, one function approach, a correct approach when you are talking of a rights discourse? What does a parliamentary committee do? Suppose the parliamentary committee is enforcing the provisions of the Narega, or suppose the parliamentary committee is exploring the impact of the food security law. The parliamentary committee essentially is trying to exact accountability on the part of government in discharging its responsibilities under social welfare legislation. What is the function which the court is exercising? When the court exercises its power of judicial review, the court is exacting a sense of accountability on the part of the executive in discharging its duties towards, first, the directive principles of state policy, but more significantly, in terms of the rights which individual citizens have in terms of access to education, to healthcare, to clean water, and a whole host of social welfare entitlements. So in Kalpana Mehta, the court tried to fuse these two institutional areas, the institutional area of Parliament exacting accountability from the executive, and the institutional area where judicial review is a process of exacting institutional accountability, by saying that if these two functions are essentially complementary, then there should be no anathema, there should be no real reason constitutionally to exclude reliance on reports of joint parliamentary committees in the Supreme Court. This was something which was so well assumed for the last 30 or 40 years that when the issue came up, it really had us thinking on what we should be doing. Or take the December judgment in the NCT case. Now in the NCT case, you have a whole host of constitutional amendments. A separate chapter created for the National Capital Territory. So the National Capital Territory retains its character as a union territory. It still doesn't become a state. But while retaining its character as a union territory, the National Capital Territory yet has two very significant areas where the Constitution has made a change. First, the National Capital Territory has an elected legislature. And whether there should be an elected legislature is not left to the will of Parliament by law to decide. But the Constitution provides that there shall be a legislature for the National Capital Territory which is elected by direct elected representation. Second, it also says that while the National Capital Territory will be administered by a Lieutenant Governor acting on the aid, but he shall act on the aid and advice of the Council of Ministers. At the same time, it says that if there is a difference between the Lieutenant Governor and the Council of Ministers, that difference will be referred to the President of India, and the Lieutenant Governor will be then bound by the view which is taken by the President of India on the point of difference. Now, what does difference mean? The Constitution doesn't tell you what differences are all about. It merely says that there is a difference between the Lieutenant Governor and the elected Council of Ministers in the National Capital Territory. That difference will be referred to the President of India, and the LG will be bound, the government will be bound by the determination of the President. How do you answer these points? Are there certain constitutional values which must, in that sense, infuse the process of adjudication? Now, this is not purely a rights discourse. I gave you earlier examples of euthanasia in relation to the rights discourse, and in Kalpana Mehta indirectly through a rights discourse. Here there is no rights discourse taking place except the right of the residents of the National Capital Territory to be governed by a government whom they directly elect. In that sense, well, tangentially a rights discourse, but not in terms of your usual rights discourse in 21 or 14 or 19. Now, while trying to give meaning to the concept of a difference between the Lieutenant Governor and the elected head of government, we thought that we must give this constitutional amendment a value which is consistent with the values of democracy. And the values of democracy are the value of political representation, of an accountable government, of elected governments wielding the real power, as opposed to somebody who is really in that sense not an elected arm of government but the head of state. So we construed this amendment, which brought in a special arrangement for governing the National Capital Territory, as an arrangement which enhances the basic features of the Constitution. The basic feature doctrine has been used, particularly in the rule of law context, as imposing a restraint on the exercise of the constituent power. But in the NCT decision, we used the basic structure doctrine in its converse by regarding an amendment to the Constitution as something which was enhancing those basic features of the Constitution, namely a republican form of government, of democracy itself, of representative governance, so that we would read constitutional provisions which were silent by giving them a meaning which would enhance those basic features or structures of the Constitution which that amendment was intended to achieve. And then finally you have, I thought I'll dwell briefly on the decision in 377. 377, the judgment in Johar, really represented in that sense the battle between laws of a colonial origin and laws which must truly represent constitutional values. That was the first layer of the battle. If you see the judgment, you will find that in every one of the judgments there is really a layered argument which is taking place. At a certain level, the judgment reflects this concern about the need to harmonize pre-independence or colonial laws with the emerging ethos of constitutional jurisprudence. The second level at which the judgment does operate, and I think which is perhaps the more significant level, is the level where we try and give individual dignity, the autonomy, the choice, the liberty of an individual, some substantive content. And therefore you find that though in some judgments in Johar, there is a reference to the fact that, well, I am as I am, let me be as I am. There are other judgments which do not regard this right to be as I am or let me be as I am really as something which is immutable. Because even within identity, if you read Amartya Sen, for instance, you would find that many of our identities, though they are seemingly immutable, they may not be as immutable as they appear to be if you look at them in a very disjunctive manner. Gender is gender in that sense an identity which is not shaped by our social milieu. If it is, as I believe all identities are shaped by our constant interactions with each other, by our interactions with society, by our interactions with our own selves, in which case in that sense you cannot postulate that there is any one identity which an individual possesses which is constant over time or constant in relation to society or that individual himself or herself. And I believed, at least when I wrote that judgment, that it is important for us to recognize these fluidities of human experience, including the fluidities of sexual experience. So much of Johar in that sense is about trying to answer what we tried to explain as the binarities or the polarities of gender and sex. What 377 did essentially was to say that, well, this is how a man should be. This is how a woman should be. This is not what a man is, or this is not what a woman is. And I think by bringing focus on the binarities, the polarities of gender, 377 was deeply offensive to the ethos of a liberal constitution. a very crucial issue in deciding 377 was, how do you deal with sexual orientation and the expression sex in Article 15? Does sexual orientation emerge from sex under Article 15? Personally speaking, for myself, I interpreted 15 in a slightly different manner than what Nalsa had, by speaking of 15 not so much in terms of sexual orientation being a part of sex as much as by speaking about 377 as imposing deep prejudices in terms of gender stereotypes, and which was found to be offensive to 15. Now 15, as you know, also uses the word only. The state shall not discriminate only on the grounds of religion, race, caste, sex, or place of birth or descent. What does the word only mean? If you follow a very formalistic rule of law approach, only means that the moment you have discrimination on the grounds of sex plus something else, that discrimination is valid and that will meet the test of Article 14. And that was in fact the view which was held in Nargesh Mirza. But is that really a correct assessment? What if the legislature uses ostensibly something apart from sex to discriminate, where the impact is disproportionately on sex? Or what if the legislature decides to use something apart from religion to cause discrimination, and the impact is on your right to religion? Would that pass muster using the Nargesh Mirza test, or the word only? If you give the word only a very literal meaning, it would pass muster. But in Johar, we thought we must really explore these boundaries of our constitutional law by postulating the intersectional nature of discrimination. And I believe that what constitutes these intersectional aspects of discrimination would of course be evaluated in future cases as we evolve in our constitutional jurisprudence. But above all, I think Johar emphasizes the need for equal citizenship. Johar also emphasizes one critical ingredient of the rule of law, which I think we need to emphasize today more than ever, which is that the rule of law, if it has to flourish in a constitutional democracy, has to flourish in a society which is based on a diversity of cultures, in a diversity of ideologies, in a plural society where individuals must be free to draw and flourish and be enriched and perhaps sometimes be poorer by their own experiences. I'm sure all of us have had our own experiences, some of them fantastic, some of them which have left us a little poorer. But I think being poorer in terms of your experiences of life and living is intrinsic to your ability to develop as you come along. And then I think the most favorite part of writing this judgment in Johar for me was to sort of incorporate this quote from Leonard Cohen. I mean, Cohen and Bob Dylan are my unmitigated. I idolize both Cohen and Bob Dylan, and I found this obscure quote, and I listen to this song very often, and it says, "Democracy, it's coming through a hole in the air. It's coming from the feel that it ain't exactly real. Or it's real, but it ain't exactly there. From the wars against disorder, from the sirens night and day, from the fires of the homeless, from the ashes of the gay, democracy is coming." So, you know, we also need to understand that when you talk about the rule of law and you talk about democracy, and the position of the rule of law in democracy, we need to understand that in recognizing the rights of others in terms of our constitutional discourse, we are not just empowering them whose rights we recognize. We are not just, in that sense, recognizing the entitlements of others. I think more important or equally important is the effort of the Constitution to transform ourselves when we recognize the freedoms of others. Too often we believe of our own freedoms. We don't dwell on the importance of recognizing the freedoms of others, because it is in recognizing the freedoms of others that really society is constantly being transformed, and society is then being evolved. And that's why I felt that we need to ask ourselves that if we don't ask very difficult questions to the forms and substances of injustice in our society, we risk being not merely the inheritors of an unjust society, but the causes of an unjust society. So, as I conclude my presentation before you, let me just say that when we speak of the rule of law, there is a tendency to overemphasize the importance of the adjudicatory function. Particularly when you have judges and lawyers, we always believe in the importance of the work which we do. But I think the message which I will leave you with is that every day of our lives as judges, you also learn of the limitations of the work which you do in terms of its ability to answer injustices, which means that we need to create social structures. We need to create individuals like you, individuals who would in that sense further constitutional values. One of my law clerks told me just yesterday, and she said that, you know, helping you with the research and this judgment has been enormously motivating and life-changing influence, because it's not so much about the doctrine that we discuss and the doctrine that we write, but the manner in which that doctrine transforms ourselves and in hoping to transform others. So I'm sure that much as we as law students and lawyers and judges focus on the rule of law and the importance of the adjudicatory institutions of the state in enhancing the rule of law, we need to realize that there's so much of life beyond the law. And we understand the law when we understand the life which exists beyond the law. Thank you very much.
Thank you very much, sir, for your words of wisdom and for your valuable opinion on rule of law, which has become inevitable for any constitutional democracy, particularly ours. Thank you so much for the wonderful oration, and particularly for your message, the lovely message for us and for the students. Life is so much beyond law. Thank you for these words. And now I request Professor G.S. Bajpai, Registrar, National Law University, Delhi, to deliver the vote of thanks.
Friends, be you ever so high, the law is ever few. Fuller said long back. In today's oration by Honorable Justice Chandrachud presented a wide terrain of the conception of rule of law in a democratic society. And it's my privilege to just reiterate a couple of things before offering the vote of thanks to put the entire discussion in perspective. Friends, this oration has very vividly brought out the understanding of rule of law on two very interesting counts, which is characterized by the entire presentation by Dr. Chandrachud. One is that we are thinking and conceptualizing the rule of law notion in the shape or in the form of rule of law as a rhetoric, which is the conventional understanding or the formalism of law, the way we conceptualize, and that is predominantly the situation when we interact
with the black letter law. So in most cases, we tend to imbibe the notion of rhetoric of the law. So the first part of Dr. Chandrachud, when he was talking about the conceptualization of rule of law, starting from Dicey, and in fact, this entire conception, as we look back, we find that Magna Carta 1215 was the first occasion when rule of law was formally codified, and since then Dicey and subsequently the Second World War experiences, the arrival of United Nations, and many things have shaped the formalization of rule of law. I think more than that, when Justice Chandrachud talked about the issues, I think he brought, that part was so fascinating through 5 issues that he discussed, and he placed the entire discussion, rule of law in the context. Rhetoric of the rule of law and reality of rule of law is something which is the core understanding which is emerging from this discussion. And especially these days, what we find in the classroom, that after understanding the formal structure of the rule of law, the formal understanding of the rule of law, we invariably tend to understand or try to understand as to what are the challenges which are happening in terms of the realization of rule of law. I am reminded of a very powerfully written 2 works which are very relevant in this discussion. One was Without Rule of Law. This is the book by Joe Nobody. Joe Nobody is not the name. The author has kept the name hidden for various reasons, because he was challenging the situation in the post-terrorism era in the US, where the rule of law was being compromised significantly. And through this book, he was trying to portray the situation where the rule of law was almost getting vanished in several situations. People were losing their rights in this. And second is a very beautiful work by Rule of Law by Tom Bingham, which is a very classical work which we read. And lately, The Rule of Law and Misrule of Man by Scarry, which is again presenting the US situation where, so these works are presenting the rule of law discourse in a context. And that is the entire debate which is happening and which is making it so. Friends, while closing and while just highlighting the importance of this topic, one thing I'm reminded, which Justice Chandrachud has also highlighted throughout his narration, and he was trying to present the issues which are emerging from this discourse. A very great effort is happening where the World Justice Project of Law, a rule of law indexing is happening since 2016, and this report is saying something what you are actually trying to say, and I'm just trying to present a couple of points to contextualize what Justice Chandrachud said. And this report said that a majority of countries worldwide saw their scores decline in the areas of different areas. So this report is basically measuring the state of rule of law in various countries. So what is the state of rule of law in different countries? This report says there is a score decline on the count of human rights, because human rights is the first casualty when rule of law is compromised. Second, checks on government powers. Third, civil and criminal justice. Checks on government powers, civil and criminal justice. The greatest decline was seen in factor number 4. That is fundamental rights, where 71 countries dropped out of 130. So this shows the crisis, and which measures the absence of discrimination, right to life and security, due process, freedom of expression and religion, right to privacy, freedom of association and labor rights. The second greatest decline was seen in factor 1, that is the constraints on government powers. 64 countries dropped out of 113, which measures the extent to which those who govern are bound by the law. So friends, this gives us a lot of thought to ponder over further in terms of what was said through this lecture. And I take this opportunity on behalf of the National Law University, Delhi, to profusely thank Honorable Justice Chandrachud for sparing his time. He was due to come to this institution for various a long time really, but it could not happen. But today he has graced the occasion on this Justice Bodh Sawhny Memorial Trust event. This is the 19th annual Bodh Sawhny Memorial Oration. Thank you, sir, for being here and gracing the occasion. And I request on behalf of the student faculty that sometimes kindly spare your time and to be with us. And these days, through your judgments, you are being considered to be a torchbearer as far as human rights activism and constitutional discourses are concerned. Your lectures and your expressions are widely quoted in classroom. This is what I can say on behalf of the student. Thank you so much for your presence today. I am also thankful to Mrs. Meera Nath, the Managing Trustee of VRSMT, and for your arrangement and providing this opportunity for us to organize this lecture. I also thank Mr. Nath, Dr. Nath, for gracing the occasion. And of course, our Vice Chancellor, Professor Ranveer Singh, whose patronage is something which always inspires us to go ahead. And I also take this opportunity to thank all the faculty members and the guests, especially Justice Narayan and Mr. Raghavendra, the Joint Secretary for Law and Justice, and a lot of guests and friends from the media and other places. Thank you so much for joining. And of course, the students today. And I'm sure it was a music to ears and a treat to our thoughts for being here and listening to Dr. Chandrachud. And thank you one and all.